Video on the night of the incident, you can hear one of the firemen say, "Gandhi ji pe aag lage hai," which means Mahatma Gandhi is literally on fire, referring to the Mahatma Gandhi insignia on those currency notes. A few questions need some very critical answers. Number one, does Justice Varma's defense so far cut ice? He is categorically put it out there that he or his family had nothing to do with this cash. He didn't even go to that outhouse, neither did anybody in his family. A lot of people, his staff, as well as even outsiders, possibly had access to that outhouse. So this was a frame-up job and he was being framed up. Does that defense cut ice? Number two, so far the actions that have been taken, the remedial actions by the Chief Justice of India, as well as, of course, the three-member panel that he has constituted, they have gone to the venue, they have spoken with Justice Varma, they have also spoken with the first responders, both the fire service personnel as well as the police personnel who reached on the spot. They are expected to give their assessment, their conclusion, their study to the CJI sometime next week, and then the CJI has to take a decision as to whether prima facie there is material on record that's been brought forth so as to ask Justice Varma to step down. Of course, if he doesn't step down, then we go into the lengthy and complicated legal procedure of trying to impeach a judge. It's also raised a larger question. How long more can the higher judiciary in our country continue to pretend that there isn't a problem with the current system of appointment and, more importantly, as in this case, the removal of judges? But is the answer to that question, as the government would want to have it, the bringing back of the failed National Judicial Appointments Commission, which was passed in Parliament but was struck down by courts? Joining me now, our full panel: Justice retired B.A. Khan is former Chief Justice of the Jammu and Kashmir High Court. Mr. Satyapal Jain is Additional Solicitor General of India. H.S. Fulka, Senior Advocate at the Supreme Court, will be joining us. Karuna Anandi, Senior Advocate at the Supreme Court, and also Aragya Sengupta is Legal Scholar and Founder and Research Director at Vidhi Legal. Justice Khan, let me start with you first. The concern that people have and have been having since we've seen these pictures of burning wads of currency notes is, why is there no action being taken? Why is the judge's defense being considered at face value? Because if this happened in anybody else's house, an ordinary citizen's house, the cops would be all over it, and IT and CBI and ED would be all over it. Why have we not seen any decisive action in the 2 weeks since this incident has happened?
Zaka, there seems to be some misconception about the action to be taken by the judiciary and the action which can be taken by the police on a registration of an FIR. When a complaint is lodged against a judge, there is a set procedure how to deal with it, because we don't have any law which covers the accountability part of a judge. I will tell you the history of that also, how we have failed and how we have not been able to enact such a law, if you want me to. But for the present, may I tell you that the field is covered by a Supreme Court judgment of 2019, which provides for a 7-step procedure. 7-step procedure, out of that, I think 4 steps have already been exhausted, and Chief Justice of India has no option but to go by that procedure. Now, at the moment, Chief Justice of India has set up a committee which is covered by the 4th step. That committee will report. Once that committee reports, then Chief Justice of India, on the merit or substance of that report, will ask the judge concerned whether he wants to quit or face action. Depending upon his reply, the next step would be to recommend impeachment against the judge to the President of India. Then the President of India will set that impeachment motion to the Parliament. Then it goes to the Parliament. Now, if it is approved by the Speaker of the Lok Sabha, or in case Rajya Sabha Chairman, then an inquiry, one more inquiry takes place under the Judges Enquiry Act of 1968, and that's a trial of a sorts. You are talking about what a criminal action and what. Now, this is one side of the. After that inquiry is complete, then it gets to Parliament back and there is a vote. But unfortunately, then politics plays, and as you must have also observed,
Yeah.
in Ramaswamy's case, it was not backed up by a political party and it failed. And Ramaswamy continued till he retired. And even after retirement, he was appointed as chairman of the Human Rights Commission. Similarly, in other cases where all actions were on and the judge concerned resigned, for example, in Dinakaran's case. In Dinakaran's case, an inquiry was set up, it was going on, and in the midst of it, Dinakaran resigned,
Yes.
frustrating that inquiry. Then the question arose whether the inquiry should go ahead and propose its whatever penalty or whatever. But that didn't happen, that was not allowed, that's lying still in the Supreme Court. Now this is the procedure, what I am wanting to say, that Chief Justice of India is acting according to the procedure, he has no option, and that procedure is laid down.
But if I may, let me
now
ask.
the other side of the other side, give me a minute. The other side of it is the criminal liability. Why is he not being dealt with under that? For that, the judiciary being a separate class, any criminal complaint against a judge has to be permitted and sanctioned by the Chief Justice of India. If somebody is wanting to go to proceed against him and file an FIR, he has to take permission from the Chief Justice of India. Now in this case, all these gaps are there, and one is wondering that why the police doesn't register an FIR and seek the permission of the Chief Justice of India.
Okay.
And so on.
Presumably
Now,
the Chief Justice
picture of
is
taking
waiting
action,
for the three-member in-house panel to come to a conclusion and then basis that decide what the next course of action is. But Mr. Jain, this is precisely the problem, that the procedure to remove a judge, to impeach a judge, is so legally complicated and lengthy. And as I understand, not a single judge in the history of India in 75 years has been impeached, precisely because the process is so complicated and deliberately stacked up so. In this case, let's say the committee comes back with their report, whatever their conclusion is. If the Chief Justice feels that there is merit to ask the concerned judge to step down, and if the concerned judge says no, then we're basically looking at months, if not years, of this exhaustive legal process at the end of which one does not even know if the judge will be impeached. And if you were to go by history, no one has, Mr. Jain. That's the frustration.
You see, I by and large agree with the observations made by the Honorable retired judge who spoke before me. You have put a very pertinent question at why so much procedural lapses in this matter. But at the same time, let us not forget that we are dealing with the judiciary which is supposed to act independently, judiciously. There are about 1100 judges in the high courts in the entire country, of which about 850 are the permanent judges. 4 or 5 incidents have come, Ramaswamy, Smitra Sen, Dinakaran, etc., etc., etc. So when you evolve a system of investigation or inquiry, you cannot treat them like the other civil servants. You have to see to it that the judge is given a fair opportunity, fair chance of defending himself before any action is taken. I totally agree, it's a very long procedure, and I think now time has come when all the parties sit together. It's not an issue of either different political parties, it's not an issue of judiciary versus executive or versus legislature, it's an issue concerning the nation. We have to now find out some solution out of this house, how to shorten the inquiry, how to shorten the procedure, what improvements can be made so that such incidents do not keep on dragging for a long time.
No,
I must admit one
again,
thing.
here's the thing. Can I just take 10 seconds? Here's the problem. You know, the first 4 steps of the procedure, as has been outlined by Justice Khan, are absolutely valid and well taken. There has to be an in-house committee inquiry. The committee has to come to a conclusion. The person concerned has to be given a chance to put forth his or her point of view. And then the CJI has to come to a considered opinion whether he or she feels that yes, the person needs to step down. All of that is accepted. The problem starts thereafter, that if the concerned judge digs his or her heels in, that option would not be extended to you or me or any of the lawyers on the panel here or any ordinary citizen. I mean, if a committee inquires and has found you and I prima facie having committed an error or an offence, then naturally the criminal proceedings will follow thereafter. In this case, the judge has the option of digging his or her heels in. And then you have God knows, how many month or how many year long procedure to impeach him or her.
See, I totally agree with you. The problem or the question is, this is the procedure which has been prescribed by the law, by the constitution. And if you have to amend it, you have to bring certain changes. It can't be done by one party, ruling party or opposition party. The point which I made earlier and I am repeating, I think now the time has come when all the political parties, judicial people, retired, serving and all, sit together and in view of the situation that has now come, rethink, revisit that and can just examine, can we suggest some new media, can we suggest some via media, not via media, a new method. I am totally appreciative of the Chief Justice and the Collegium actions they have taken within few days. Inquiry committee has been constituted. It consists of 2 Chief Justices and an Honorable Judge which are inquiring into it. I am very hopeful within few days they will submit the report. At present you have to follow the procedure which is prescribed by law. If you want to amend the procedure, then again I say there has to be consensus and unanimity among all the stakeholders. The Honorable Judge referred to Mr. Ramaswamy. Mr. Ramaswamy's case, just a minute. Ramaswamy's case, everything was done when impeachment motion came to voting. The ruling party, the Congress party at that time, on the ground that he is from South and so, all other constitutions they must be hanging, they did not vote and the impeachment motion fell down. So, if you ultimately after everything have to consider other things which are not the merits of the case, then whatever system you may have, ultimately the result will be the same. We have to rise above political consideration. We have to rise above personal consideration
fair point.
And see to it.
Let me ask Karuna Nandi. So here are the actions that have been taken. So CJI derosters the concerned judge, says he will not be given any judicial work. He's been repatriated back to his parent high court, which is the Allahabad High Court. There, the Bar Association goes on an indefinite strike. They're saying, we're not some kind of trash can that you can just, send us judges who are under a scanner of suspicion. There are, I believe, about a dozen bar associations across various states who are in the process of meeting the law minister and so on and so forth. Again, the point is, if this happened to any normal person, the first thing that would have been asked of him or her is to step down pending inquiry. Somehow, the procedure, the laid down procedure in the case of a judge does not account for that. He's still in an influential position. He still is a high court judge, even though he has no work in front of him.
So that's exactly what's happened in the case of Justice Varma. His work has been taken away from him. So he is not in a position then to influence, to pass judgments. He has basically been asked to, in effect, step down. I do want to say, though, that a judge is in a very different position from you or me. And the reason is this, that in a situation where the government is the largest litigant in the country, and where political parties come before him, where big industrialists come before him, where the biggest mafia dons will come before a particular judge, that hugely unpopular decisions are required to be made by these judges. And so therefore, and they also give up a certain amount of money, they get status, but they give up a certain amount of money, they give up various things also in order to do this work. They also acquire some things, there's no doubt about that. So therefore, to have a preliminary, something like a preliminary inquiry is something that is absolutely vital. What is happening at the moment, and let us be clear that less than a week has passed, and already the Chief Justice of India has set up an inquiry committee of 3 High Court Chief Justices who are far from either Allahabad or Delhi. It's the Chief Justices of Karnataka, Himachal and Punjab and Haryana. Let us see what that inquiry report says. It's very important also, I think, to understand that a person, any person, is innocent until proven guilty. The Chief Justice always has the option to ask for an FIR to be registered at some point. In fact, I think yesterday he agreed for a plea in this regard to be listed before him.
Okay.
He has the option to do suo motu. Let us see what this inquiry report says. Let us remember that while all this money was found, we don't know how much. Can we say the fact that it was said that this bit of information was leaked, that crores of money was found burnt? How do we know it was crores of money and not just ash? How did they evaluate it? How do we know that this outhouse, and this was not in either none of the reports said that it was actually an outhouse that was very close to the staff quarters. We don't know whether it was locked or open. The inquiry report of the Chief Justice of the Delhi High Court also said quite clearly that the people who had access to this outhouse included staff, CPWD, and he didn't mention this, but presumably security. The Delhi High Court chief himself said that no cash was found, and then later resigned from his statement. So let us see what the inquiry report says, and then let us go forward with this. There are options available for the Chief Justice, and he has acted in a robust and exemplary fashion.
Let me go to Mr. Fulka, and then after that to Mr. Sen Gupta. Mr. Fulka, you know, the larger picture, and we're seeing this in Parliament, we're seeing this in terms of, the steer from the political class, particularly from the government, is that, look, we've been saying for years, we've been crying hoarse for years, that the current system of appointment / removal of judges is so opaque. It's probably the only institution where members of the institution appoint their own. There is no means of oversight there. It needs reforms. We brought in a means to do that 10 years ago through the NJAC. It was passed unanimously in Parliament, but you folks struck it down. We're now trying to revive that. Do you agree with the need for that larger debate to happen in the judiciary, that the present system of appointment and removal you can't go on as business as usual?
You see, Jaka, the collegium system may not be the best, but the NJAC is not a solution to it. It is not a substitute to collegium system. That's the worst. The government interference in the appointment of a judiciary. Now we see the high-powered committee of Prime Minister, Leader of Opposition, and the Chief Justice. Now it is not only NJAC. We have already two important positions where this committee appoint: Election Commission of India and the CBI Director. Now we have seen now every appointment of Election Commission, every appointment of CBI Director, the opposition says the government has appointed its own favorite, and it is criticized by the opposition. So the same thing we don't want to see it in the judiciary also. The same thing. Now, as far as the interference by the government, before this collegium system, I tell you, I am the one who has seen the maximum interference of the government in the judiciary while handling with the cases of 1984 anti-sex genocide. Judges, but roster was changed, cases were withdrawn from the judges. Justice Sachar gave an order that the relief camps should not be bound up because the victims have no place to go. The next day roster is changed. Justice Ward gave a judgment that there is an affidavit of the widow that Sajjan Kumar leading the mob registered a case. Roster is changed. A special Chief Justice is brought from Kolkata. Now this kind of things we have seen. It is before the collegium system. Do we want the same thing to come back? Do we want every appointment of the judge to be criticized by the opposition? So therefore collegium is not the best, but this NJAC is not the alternative. Now one thing more. Okay. What is the solution of it?
What is the solution?
Problem is not more so in the appointment. Problem is during the service. Now during the service what we need to break is the nexus between the fixture lawyers. I repeat, fixer lawyers and the judges. There are lawyers who are known, whole media know, whole bar know, who fixes the judges. And even in the Chandigarh case, that Justice Nirmal Jadhav, Mr. Jain knows it very well. This was a lawyer who has sent a bag full of the money. And this has been happening. And in this case also, from social media, the name of one lawyer has been coming, and earlier also the same lawyer, his name has figured in one case.
Okay.
Now in 1980s, late 80s, Supreme Court had said that the judges, High Court, Supreme Court judges should remain away from socializing. They should not go for parties, not partying. That is what need to be reinforced.
Okay.
Now this nexus need to be broken. There's absolutely for the judges to mix with the lawyers, to mix with the politicians, to mix with the litigants. That is what need to be done. That is the solution to the problem.
So let me ask,
Let me ask
Mr. Sengupta, what Mr. Fulka said that, according to him, the bigger problem is this nexus between certain lawyers and certain judges. Karuna was saying a moment ago that judges give away a lot of things. Of course, ostensibly they do to do this work, and there are a lot of impediments that come in their way. There are a lot of powerful interests that they take on with judgments, which sometimes can be unpopular, which sometimes can be affecting certain quarters, so on and so forth. But the point is that to pretend that the current system is okay in the name of judicial independence, that's also not okay, because the glaring loopholes are being thrown up in the system, not least of which is this case. I mean, everybody's talking about this case because the pictures have come out and, it sort of rankles your conscience to see, currency being burned. But the point is, God knows what else is happening. So the issue is, there is a tendency in the higher judiciary to say that no, anything that talks about, reform in our system or of appointment or removal will be an infringement by the political class.
So let's be clear on two facts, Saga. The Chief Justice of India has been exemplary in terms of following the process that has been laid down, but the problem is the process itself, right? So we can't blame the Chief Justice for his actions, but we have to ask a deeper question about the process. And the process isn't really about appointment. Now, it's a good debate to be having about the National Judicial Appointments Commission. Great. Practically speaking, the National Judicial Appointments Commission, if it were operational, would have had one major difference, which is the fact that this hasty transfer, which the Supreme Court has, of course, clarified has nothing to do with this incident, but I don't think that clarification really convinces too many people. But this hasty transfer may not have happened as quickly because that transfer would have to happen through the NJAC, which has judges, it had two eminent persons, and it had the law minister. But I'm not on the merits of the NJAC. The question, as Mr. Fulka rightly said, is a question in relation to a judge who is in service and what accountability mechanism is there. And unfortunately, we are stuck in the situation that we were in 1950, where we felt that these are high offices. The only thing that we need to have is a very difficult process of impeachment. Okay, fair enough. I mean, that's the extreme step. But the world has moved on from there. In 70 years now, in many jurisdictions, and this is something that was tried in India as well, in 2010, there was the idea of a Judicial Standards and Accountability Bill. The idea was that once a judge is in service, impeachment is a very, as you rightly said, as in it's a severe penalty, and it should be a little bit difficult. Let's be clear. It shouldn't be too easy. Yeah. We don't want to be impeaching judges left, right, and center.
Correct.
But what about measures short of impeachment? What about a statutory basis to ensure that a judge does not get work, that a judge gets a suspension, that other kinds of remedies that we can think of doesn't happen in this ad hoc fashion as it is happening now? So currently the Chief Justice of India, all he can do is say that, okay, judicial work will be withdrawn. And after that, we can only plead with the judge to resign and nothing else can happen. So what we need now, number one, is that we need to have a debate on a judicial standards and accountability legislation that has measures short of impeachment, even if a judge is guilty of some conduct that may not warrant impeachment, but is still wrong in some way. We shouldn't have to go all the way towards impeachment, number one. Number two, as far as judicial appointments is concerned, and Mr. Fulka is right, there may be two views on the NJAC. I myself am a supporter of the NJAC, but the NJAC itself brought in a culture that judicial independence does not mean judicial insularity. The collegium system is a discredited method of appointment. Let's be very clear on that. Yep. So I am personally delighted that the government, through the Vice President, or at least the Vice President on his own, is reviving a debate on judicial appointments, because it seems like over the course of the last decade since the NJAC was struck down, there is a kind of happy equilibrium. But we should revisit that, because the lack of an NJAC, which is the collegium, fosters a culture of opacity, which actually what it does is erodes public confidence in the judiciary. So transparency and sunlight are the best disinfectants,
Yep.
and we need to have a debate not only on appointments but more critically on judicial standards.
You know, a lot of people, as I close out, I just want to say one thing. A lot of people have been saying, oh, this is trial by media. You know, why is the media going overboard? Why are you already jumping to conclusions? Like I said, it's no one's case to try and already hang the said judge saying, oh, he's guilty, oh, money was found in his outhouse being burned. So not at all. I mean, it is entirely possible that Justice Varma is innocent. No question about it until the inquiry committee submits its report, until the CJI comes to a conclusion, and hopefully this will all be put out in the public domain because there is so much public interest in this case. But what needs to be done is the confidence restored back in the process that justice is not just done, but it is seen to be done. And because so much of this case has been out there in the public domain, we just hope that the committee's report is put out in the public domain and the Chief Justice's conclusion is put out in the public domain. And then, of course, like I said, the ball then is in Justice Varma's court. Hopefully, we'll get that decision in this coming week. Thank you very much to all our very special guests for this roundtable on what is easily the biggest talking point that we have seen in judicial circles, in legal circles, in a very, very long time because of this story over the last week. I also want to get in more voices on this. Two very special guests will be joining us over the course of the next 10 minutes or so. I want to first go across to Mr. Mukul Rohatgi, Senior Advocate of the Supreme Court, former Attorney General to the Government of India. Mr. Rohatgi, I want to first ask you about the big picture, right? We've all talked about the details, the nitty-gritties of the case. Was there money? Was there no money? Was it real? Was it fake? Etc. But the big picture is that the government feels, the political class feels, that the current system of appointment and removal of judges is not good enough. It is opaque. The government's view is they want to bring back the NJAC in some form or fashion. Do you think that's the way to go as far as reform of judiciary is concerned?
I have no doubt, my friend, that the only way to bring transparency and remove opacity and darkness is to bring in sunlight. And it is well known it is the best disinfectant. So the opacity should be removed starting from the appointments. You cannot have 3 or 5 people appointing judges in a closed room, getting inputs from their secret sources or from sources which are not open to transparency. The bar has no role to play, and the bar is the best barometer of a court or a judge or a prospective judge. So therefore, we should have a proper selection committee constituted by a law, because this selection by a collegium is actually not supported by any law. It is only a judge-made law, which according to me is not correct. It's not shown good results in any case in the last 30-40 years. We should start with that, have a broad-based system which is publicly accountable. You should have outsiders, men of impeccable character from different industries, could be from, the industry of academics, the Department of Academics, it could be from top Bollywood actor, it could be a top retired bureaucrat, and so on and so forth.
Okay.
That is the first step. The second step is this impeachment business is completely archaic. No impeachment has happened in the last 75 years.
Correct.
We need to bring in a more flexible system. You cannot have 100 MPs signing a petition for impeachment. That too, it has to go through yet another committee, a full-blown committee like a court, which will examine, cross-examine witnesses. Then it has to be debated in Parliament.
All right.
2/3 of members sitting and voting have to vote in the same session. I mean, it is completely a system which was meant to be ideal, but it has not worked.
All right, Mr. Rohatgi, very quickly, see, the issue is now because of this case, the binary choice that's been put forth is collegium bad, NJAC good. The last time NJAC was struck down by the Supreme Court, a constitutional bench of the Supreme Court, they had specific concerns about 2 individuals out of 6 getting the veto power. How can that concern be addressed specifically?
No, my friend, we can have a relook at that system. Firstly, why should there be suspicion? Why should there be suspicion against the government or ministers? I don't see any reason for this suspicion or negativity. But even if you have that, we can tinker with it. As Attorney General, I had told the Supreme Court, we can have a slightly modified committee. Let this committee work for a year. You can see how it performs. And if you don't want them, add 2 more people. As I said, add a man from public life. The retired top bureaucrat or a top CAG or a top RBI governor or a man who's been given Padma Vibhushan, who has no stake in selecting somebody. Why can't you have that? It's a country of more than, how many billion people here? And we find out 5 or 10 people against whom nobody can raise a finger, and everything should be under a public gaze. That is what is the need of the hour.
All right, Mr. Mukul Radki, former Attorney General to the Government of India. Thank you very much, sir, for speaking with us here on CNN News 18. Thank you. All right, so it's been 2 weeks since this case came to light, since it happened. It's been over a week since it came to light. Does the judge's defense add up? And more importantly, I also want to talk about the larger push from the government that there needs to be judicial reform. And one way the government certainly feels is to bring back the NJAC. We'll talk about both of these issues to Dr. Abhishek Manu Singhvi, four-term MP and senior advocate in the Supreme Court. Thank you very much, sir, for speaking with us. I want to first talk about the specifics of this case. Justice Varma's claim is that, look, he's being framed up. Him and his wife were not there when this incident happened, when this fire happened. He doesn't know who had access to the outhouse, staff, outsiders, etc. Does the judge's defense so far cut ice, according to you?
I will answer the question, though, Zaka, I think it's partly an unfair question, unfair both to the judge and unfair to society as such. We are not privy to all the information. We cannot pass judgment like that either against him or for him. And we have to be very, very careful and meticulous and, in fact, hesitant to pass that kind of judgment. The committee, which has prima facie, the collegium, which has prima facie found it sufficient to deny him judicial work, may well have got information which is of a non-verified nature. And really the correct answer to your question is when the committee appointed gives a report. That's point 1. Point 2, having said that, there are 3 or 4 burning questions, to use a misplaced pun or metaphor, which arise, which have not seen the light of the day even after 2 weeks or 3 weeks. One, and these are important for me to answer later on, or anyone to answer objectively the question you asked. Who opened the door or who broke the lock if there was a lock? There has to be, as you know, even if I enter your house, forget a judge's house, a punchnama, punch witnesses, videography, etc., etc. I can't just break your lock and get into your place. Was it locked at all? If it was locked, how it was opened, and what was the first responder's first sight? These are 3 crucial questions which are pending, and we have no answers. Then, of course, how much money? We've got all these memes from 50 crores to 15 crores to 700 crores. I mean, burnt cash, how it is counted as that many crores is a mystery to me. Having said that, a lot depends on the inputs given on these questions by the police and fire department to the committee, which will decide whether the possession and seizing of this property was exclusively within Mr. Varma's, Justice Varma's family or his, main persons, or was it open? So that alone can be, and I think it's important to exercise that restraint, because tomorrow, if there is the slightest exoneration, it is irreversible stigma if you start passing judgment like this. Equally, if there is something prima facie, I think, it needs to walk the full process.
So, Dr. Singhvi, can I ask a very simple question? That is that, your house, my house, and presumably the judges' houses are, big bungalows. You and I have all been to, judges' houses. There must be some kind of, visitor log, CCTV footage. If Justice Varma's defense is that outsiders did this, there must be something in the last 2 weeks that could have been put out in the public domain to show that, look, it sort of, concurs what the judge has been saying.
You're absolutely right, which is why I said you need to be a little restrained and, hurry cautiously or hasten slowly. There is no doubt there are only 3 possibilities. Somebody from Justice Varma's family put it there, somebody from outside put it there, or somebody inside like an employee, etc. So there's no 4th possibility as such.
Yes.
Now, the entry of this cash or these sacks, so-called, etc., would be definitely on some CCTV. It would be known to some guard. It would be known to some person. And that is why those people will be questioned by the committee. B, as I said, most importantly, was there a lock or not? It strengthens Justice Varma's case a lot, and as you've seen from his statement. If it's an open place, framing is one part of it, but certainly it could be accessible to anybody who can throw not a very large amount of burnt currency. You know, burnt currency might sound large in the memes. It could be a fairly smallish amount which could be thrown there and kept there. So these are things which we need to, but I think prima facie, it looks bad. I mean, to be fair, prima facie, it looks bad, it looks odd. Rest must await, and he will have his full chance. So there are a lot of questions which is more important with you, but this is certainly not the time to castigate. Because see, let me tell you unreservedly. One, I'll just deviate from your question for 30 seconds. I think the process adopted by the CJI is unexceptional. It deserves kudos and congratulations for being prompt, for being transparent, for being unprecedentedly putting things in the public domain. There has been criticism of his saying that he's put evidence in the public domain, but he's simply done what was reported to him. So that part is creditable. Secondly, and ironically, I would rate on the basis of performance, on the basis of interactions, on the basis of appearances, Justice Varma is one of the finest judges of the court. Yes. I mean, his enemies would not contradict that statement of mine. So it's a very sad irony, which is why we need to exercise restraint and await the details. And I have no doubt this committee of fairly competent and senior judges will have at least a very major base. So one final word, and this is a larger picture, larger debate, which obviously, you know, you're a member of parliament as well. You've seen this in the house that you belong to, where the government concertedly is pushing that, look, this would not have happened if there was judicial reform. We need to start talking about NJAC. The vice president sort of taking the lead on this. Isn't that a valid debate at a time such as this? That, okay, you don't like NJAC in its previous form, the court struck it down, but you can't have the current system, which everybody knows the opacity of it. Zaka, the debate is certainly valid. In a democracy, if you don't have debate, it's a dead democracy or a non-democracy. Number two, the debate is topical because such kind of things raise the issue. Number three, I have no hesitation in saying that the collegium system suffers from very serious flaws. I will not say it has failed completely, but serious flaws, possibly fatal flaws. Number four, I would also not hesitate to say that from the time when we started practice and today, large sections of the judiciary perceptually are in the crosshairs of doubt, serious doubt, which is not the way it was in the old days. And I think there is a great need to strengthen them, their perceptional, reputational image. But having said all that, I am not one of those, and I've seen many on your programs, who go and look for a knee-jerk press button solution that you had this problem, use the peg of Justice Varma to hang an NJAC as the magical panacea for all your ills. An NJAC, mind you, I was the one who opened the debate. I was the lead speaker in the NJAC bills, and the various moves there, which passed with 99%. So in principle, the entire spectrum of political parties supported it. But you have to also keep in mind a countervailing factor of the control of the executive, direct, indirect, implied, explicit, subterranean, overt, over the judiciary. If you can exercise control over sections today without the NJAC, you need to ask the question, how will that control deleteriously increase after an NJAC? And how prejudicial it would be for independence of judiciary. So again, we have to hasten slowly. I think the best answer is let the government, not MPs, not even the chair of the Rajya Sabha, not anybody else, the initiative of presenting a draft form of a proposal of a reformed, improved, a less faulty NJAC come to us, and certainly it should come and we can discuss it.
All right.
But do not use this peg to jump to an NJAC solution, because I can assure you it's not going to be a panacea for your problems.
All right, Dr. Abhishek Manu Singhvi, we'll leave it at that. Thank you very much. It's always a pleasure speaking with you. Thank you for your time and your perspective. Thank you. US President Donald Trump has decried concerns over the transmission of military plans on the messaging app Signal. He's called it a witch hunt. he has sought to deny the seriousness of the leak in which his top national security officials seem to have tied themselves up in knots.
I want to find if there's any mistake.
The president addressed reporters from the Oval Office in the White House on the very same day that some top members of his intelligence team faced very sharp questions from the House Intelligence Committee. Trump's top national security team is accused of using a consumer messaging app, Signal, to discuss planned American military strikes in Yemen. And there were messages with details of the precise time of the strikes, which were published on Wednesday by The Atlantic magazine. In fact, this whole controversy came to light when the editor-in-chief of The Atlantic, Jeffrey Goldberg, claimed that he had been inadvertently added to a group which included the likes of Michael Waltz, the National Security Advisor, Pete Hegseth, the Defense Secretary, and Marco Rubio, the Secretary of State, among more than a dozen others.
Good afternoon, everybody.
Days after the leak went public, Trump and his aides were still trying to downplay it and have yet to establish a coherent narrative to push back.
I don't know anything about it. I'm not a big fan of The Atlantic. To me, it's a magazine that's going out of business. There was no classified information, as I understand it. They used a app, if you want to call it an app, that a lot of people use, a lot of people in government use, a lot of people in the media use. Well, yeah, Mike Waltz, I guess he said he claimed responsibility, I would imagine. It had nothing to do with anyone else. It was Mike, I guess.
It's embarrassing, right. Yes. We're going to get to the bottom of it.
Michael Waltz is the National Security Advisor of the United States. He said in an appearance on Fox News that he had created the group and he would take full responsibility for the leak. Trump and his White House administration officials have also insisted for days now that the information that was leaked in the Signal chat was not classified information. But President Trump appeared to backtrack on that claim in his Oval Office remarks that happened Wednesday after the full transcript was released by The Atlantic magazine. Trump instead said that he was ultimately not so much concerned about the leak itself, going on to proclaim that no harm was done because the attack on the Houthis in Yemen was unbelievably successful. The new messages published by The Atlantic showed that the Defense Secretary Pete Hegseth had shared critical details of the upcoming operation against the Houthis. Most crucially, there was precise timing of the launches of F-18 fighter jet aircrafts from aircraft carriers that were there in the Gulf of Aden. Those same F-18s were to then go ahead and strike the Houthi targets. The exact time of those strikes were also detailed in those chats. It also describes one of the main targets as the main missile man of the Houthis, even though he's not been named. All of which, if this information had fallen in the wrong hands, it could have completely upended the strikes. It could have even put active US military personnel in harm's way. Hegseth was under immense pressure even in his Senate confirmation hearings. Eventually, J.D. Vance, the vice president, had to use his casting vote in the Senate to break the tie of 49-49 each. There were all kinds of accusations against Hegseth, including a major alcoholism problem, having sex with a minor, multiple affairs with different women. Hegseth, though, did not offer an apology in his remarks to reporters in Hawaii. He's on a four-nation tour right now. He has once again relied on semantics and the argument that the disclosures made as part of the Signal chat were not war plans. He insisted that no specific details, no names were revealed in the Signal chat.
Nobody's texting more plans. I know exactly what I'm doing, exactly what we're directing, and I'm really proud of what we accomplished, the successful missions that night and going forward.
But Hegseth did not quite address how a disclosure, which he released 30 minutes before the fighter jets took off from the Gulf of Aden and 2 hours before the strikes began, how that did not constitute as an attack plan. In fact, there is now political pushback as well against the Signal chat leak. Senator Roger Wicker, who is the Republican chairman of the Senate committee which has oversight over the Pentagon, became the first member of the Republican Party who has called for an independent review. Wicker is one of the toughest Republican critics of Pete Hegseth. He has joined Senator Jack Reed, who's a top Democrat on the committee. Both of them are now saying they're going to request an expedited investigation by the Defense Department. Secretary of State Marco Rubio confirmed while he was on a visit to Jamaica that he too was among the members of the chat group and that someone had made a big mistake in adding Jeffrey Goldberg, the editor-in-chief of The Atlantic.
Obviously, someone made a mistake. Someone made a big mistake and added a journalist. Nothing against journalists, but you ain't supposed to be on that thing.
But senior members of Trump's intelligence team, the CIA Director John Ratcliffe, the Director of National Intelligence Tulsi Gabbard, and FBI Chief Kash Patel were grilled by the House Intelligence Committee for the second day running. And during the course of that interrogation, there were quite a few awkward moments and uncomfortable questions that were asked of Trump's top intelligence gatherers. Gabbard in particular had to walk back on some of her comments from Tuesday, where she said that operational details were not shared in the Signal chat.
It was a mistake that a reporter was inadvertently added to a Signal chat with high-level national security principles, having a policy discussion about imminent strikes against the Houthis and the effects of the strike.
Senior members of the Trump administration have offered a series of shifting and sometimes even contradictory explanations for how this episode occurred. They want to steer the conversation away from the leak itself to how the actual operation was and how successful the actual operation was. Trump has insisted that no classified information was shared among the members of the group. He also insisted that it was not uncommon for members of his government to use Signal or any other commercial messaging app for official business. He has also spent a lot more energy disparaging the Atlantic and the journalist in question, Jeffrey Goldberg, than actually defending his NATSEC officials. He even called the Atlantic a failed magazine. This same persecution complex strategy has been used by Trump in the past to wriggle out of numerous criminal investigations against him in the last 4 years. The President and the Secretary of Defense, that's Trump and Hegseth, have the ability, as per the US Constitution, to even retrospectively claim that certain information is declassified. So even if the information that was shared by Hegseth and this group was deemed to be classified at the time that it was shared, both he and the President have the power to declassify it. Former national security officials, though, have said that they are very skeptical about the information shared by Hegseth, saying that it looks classified to them, particularly given the specificity and also the life or death consequences for US military personnel who undertook the mission. This is the first big controversy in the 2 months that Trump has been in office. If it will cost any of his top national security lieutenants their job, that is still an open question.
I've been speaking to eyewitnesses very specifically in Thailand about what they experienced when the quake hit. Here is some of what they have been telling us.
So basically, when the earthquake struck, we were all in our rooms, like having just woken up and just relaxing, and then we feel these tremors in the rooms, and everyone was so shocked. And then the hostel staff made us all evacuate the rooms, and we didn't really have any idea. And then when we were outside, what had happened. Yeah.
And how would you describe how people felt? Not just the physical feeling of those those tremors, but how were people?
Yeah, I think all the travellers who were all in the hostels were very scared and didn't know what was going on really to start with. And then one of my friends, Gammon, he went to the MBK Mall, and so he was there to go shopping for the day to see what it's like. And then when the earthquake struck, everyone was running out, and it was all getting evacuated, and he could see rubble falling from buildings, and he was very shocked as to what was going on.
Yeah, actually, I don't go outside because I'm afraid of having that again. That's why. But I also see a lot of damage, especially from Bangkok. From Bangkok, so I have friends and also relatives there, and also they cannot stay in the condominium. They have to stay outside, and some of them they have elder mother. So that's why they are very much difficult to find a place because they cannot stay in a condominium.
Yeah, understood. And the way you felt is echoed by other people who felt, at the onset of the tremor that they had a health issue, and then suddenly you realise it's not you, it's an earthquake. Look, I want to just, before I let you go, just take a moment to focus on the women of Myanmar. What will be the impact, short and longer term, of this earthquake for them?
Yeah, thank you so much for asking this question. So there, I also would like to highlight 5 points. One is women and men experience differently. There are pre-existing inequality between genders. For example, access to information. Women are 29% less likely to own mobile phone than men, which is the major device to get the information. Second is not all women feeling the same. Disabled, pregnant, and lactating women are more vulnerable due to their extremely limited access to health services and other basic services. That's why it also will be more burden for the women because of their care and domestic works. So, and the fourth point is earthquake and other natural disaster coupled with displaced situation can increase exploitation, trafficking, and sexual violence. We had evidence in Nugget cyclone in 2008. After disaster, women are often at high risk of mental health issues such as anxiety and depression. So people in Myanmar have already been suffering from economic hardship, conflict, and also airstrikes since, particularly since 2021. This disaster made the situation worse.
Well, I want to bring in Tom Andrews. He's along the Thailand-Myanmar border right now, and he is the UN Special Rapporteur on Human Rights in Myanmar. Your colleague at OCHA has described significant damage in Myanmar. Mandalay very close to the epicenter of what was a very not very deep earthquake at all. What's your assessment of what the impact has been there?
Very significant. Becky, you've got to realize that even before the earthquake began to shake, we had over 20 million people in need of humanitarian aid in this country, 3.5 million people internally displaced. So when that hit, this was already a disaster. Now we have a disaster on top of a disaster. And I can only shudder to think what will be happening in the next few days as rescue operations kick in. The other thing that I think is important to note, that in disasters like this in the past, the military junta of Myanmar has shown its willingness to weaponize aid. It's cut off aid to areas that are extremely vulnerable, where people need the aid. They have stopped it from getting in. It's really important that the international community get aid in to Myanmar, but also that as much pressure as possible can be brought to bear on the military junta to let aid in where it needs to go, and that we also coordinate with the opposition national unity government to make sure in those areas that are so desperate right now, aid is going to get to them as well.
Tom, which are those areas? Is it at all clear where the most pressing needs are, and how likely is it, to your mind, with your experience, that the military junta is going to play ball when it comes to these aid organisations helping out and getting access into the country?
You know, to be honest with you, Becky, I'm not optimistic. We've just seen the pattern with natural disasters in the past. They've been just completely outrageous in the obstacles they've put in the way of getting aid into areas that it really is needed. As you mentioned, Mandalay is near the epicenter. It was a major urban area. We're still getting reports from around that area and throughout much of Myanmar that really are not in great shape to begin with. So it's a horrible situation made much worse by the fact that I think this junta is going to need to have a lot of pressure, and I mean a lot of pressure, applied to it by the international community if lives are going to be saved.
Viewers, hasn't the opposition always said that it is for free speech, that it respects students protesting against authority figures, whether it is in JNU, Jadavpur, Jamia, any college? They, for example, lauded students when they, in unprecedented scenes in Kolkata's Jadavpur University in 2019, heckled former Bengal governor and now Vice President Jagdeep Dhankar. You can see those pictures in the middle of your screens, viewers. The students waved black flags. They carried placards that read, quote, BJP activist Mr. Jagdeep Dhankar, go back, unquote. When people reminded them that they were showing disrespect to a constitutional authority, they said, too bad. It's our right to free speech. And the TMC government said, of course it is. Carry on.